Let's now proceed to one of the most important parts of remedial law, that is, civil procedure. Pursuant to the provisions of Section 5, Paragraph 5 of Article 8 of the Constitution, the Supreme Court adopts and promulgates the following rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. In short, the Rules of Court was promulgated by virtue of the Supreme Court's rulemaking power. Rule 1, Section 1 of the Rules of Court provides that these rules shall be known and cited as the Rules of Court. The first part of the Rules of Court is civil procedure. Let's have a closer look at the history of civil procedure. Act number 190, enacted on August 7, 1901, was an act providing a code of procedure in civil actions and special proceedings in the Philippine Islands. In short, this was called the Code of Civil Procedure. This was superseded by the Rules of Court, which took effect on July 1, 1940, and then by the Rules of Court, which took effect on January 1, 1964, and finally, the present Rules of Court under Bar Matter number 803, which took effect on July 1, 1997. So again, the first part of the Rules of Court is the 1997 Rules of Civil Procedure. It covers Rule 1 to 71. Question: in what courts shall the Rules of Court be applicable? The rules shall apply in all the courts except as otherwise provided by the Supreme Court. So, for example, the Supreme Court, by virtue of its rulemaking powers, promulgated separate rules for specific cases, such as for small claims cases or cases covered by the rules of procedure for environmental cases. Next question: in what cases shall the Rules of Court be applicable? The rules shall govern the procedure to be observed in actions, civil or criminal, and special proceedings. A civil action is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. A civil action may either be ordinary or special. Both are governed by the rules for ordinary civil actions, subject to the specific rules prescribed for a special civil action. A criminal action is one by which the state prosecutes a person for an act or omission punishable by law. A special proceeding is a remedy by which a party seeks to establish a status, a right, or a particular fact. In what cases not applicable? The rules shall not apply to election cases, land registration, cadastral, naturalization, and insolvency proceedings, and other cases not provided for, like labor cases within the NLRC's jurisdiction, because it is covered by the NLRC rules. However, the Rules of Court may be applied by analogy or in a suppletory character, and whenever practicable and convenient. Let us discuss the case of GSIS versus Villa Visa, GR number 180291, July 27, 2010. The facts of this case are as follows. Respondents allegedly took part of a mass demonstration or rally. The manager of the GSIS Investigation Unit, or GSIS-IU, issued a memorandum requiring the respondents to explain in writing and under oath within 3 days why they should not be administratively dealt with. Okay? Respondents submitted a letter explanation denying that there was a mass action. Petitioner filed formal charges against respondents for grave misconduct and or conduct prejudicial to the best interests of the service pursuant to the Rules of Procedure in Administrative Investigation of GSIS employees and officials in relation to the Uniform Rules on Administrative Cases in the Civil Service in accordance with Book 5 of the Administrative Code of 1987. Respondents were again directed to submit their written answers under oath within 3 days from receipt thereof, but none was filed. Petitioners primarily questioned the probative value accorded to respondents' letters of explanation in response to the memorandum of the GSIS-IU manager. The respondents never filed their answers to the formal charges. The petitioners argue that there being no answers, the allegations in the formal charges that they filed should have been deemed admitted pursuant to Section 11, Rule 8 of the Rules of Court, which provides for the rules on allegations not specifically denied, deemed admitted. According to the petitioners, this rule is applicable to the case at bench pursuant to Rule 1, Section 4 of the Rules of Court, which reads that the rules shall not apply to certain cases except by analogy or in a suppletory character and whenever practicable and convenient. So the issue in this case is whether an administrative tribunal may apply suppletorily the provisions of the Rules of Court on the effect of failure to deny the allegations in the complaint and failure to file answer, where the respondents in the administrative proceedings did not file any responsive pleading to the formal charges against them. The Supreme Court held that the court does not subscribe to the argument of the petitioners. Petitioners' own rules, Rule 11, Section 4 of the GSIS Amended Policy and Procedural Guidelines number 178-04, specifically provides for the effect when respondent fails to file an answer. A perusal of said section readily discloses that the failure of a respondent to file an answer merely translates to a waiver of his right to file an answer. There is nothing in the rule that says that the charges are deemed admitted. It has not done away with the burden of the complainant to prove the charges with clear and convincing evidence. The Supreme Court held that it is true that Section 4 of the Rules of Court provides that the rules can be applied in a suppletory character. Suppletory is defined as supplying deficiencies. It means that the provisions in the Rules of Court will be made to apply only where there is an insufficiency in the applicable rule. There is, however, no such deficiency, as the rules of the GSIS are explicit in case of failure to file the required answer. What is clearly stated there is that GSIS may render judgment as may be warranted by the facts and evidence submitted by the prosecution. Okay, next case, Azuelo versus Zameco 2 Electric Cooperative, GR number 180291, July 27, 2010. The facts of this case are as follows. Petitioner Ricardo N. Azuelo was employed by the respondent Zameco 2 Electric Cooperative as a maintenance worker. It appears that sometime in March 2006, Azuelo filed with the Regional Arbitration Branch of the NLRC in San Fernando City, Pampanga, a complaint for illegal dismissal and non-payment of benefits against Zameco. The complaint was docketed as an NLRC case and was assigned to a labor arbiter. After several mediations, labor arbiter Bactin ordered the parties to submit their respective position papers on July 14, 2006. On July 14, 2006, Azuelo, instead of submitting his position paper, moved that the submission of his position paper be extended to August 4, 2006, which was granted by the labor arbiter. So on August 4, 2006, Azuelo again failed to submit his position paper. The labor arbiter then directed Azuelo to submit his position papers on August 22, 2006. On the said date, Azuelo, instead of submitting his position paper, moved for the issuance of an order directing Zameco to furnish him with a complete copy of the investigation report as regards his dismissal. Zameco opposed the said motion, asserting that it has already furnished Azuelo with a copy of its investigation report. The labor arbiter dismissed the complaint for lack of merit, ruling that the complainant failed to file his position paper. Azuelo again filed a complaint with the Regional Arbitration Branch of the NLRC in San Fernando City, Pampanga, for illegal dismissal with money claims against Zameco, containing the same allegations in his first complaint. Zameco filed a motion to dismiss the second complaint, filed by Azuelo, on the ground of res judicata. Azuelo opposed Zameco's motion to dismiss, alleging that the dismissal of his first complaint was without prejudice. The labor arbiter issued an order which dismissed Azuelo's second complaint for illegal dismissal on the ground of res judicata. Okay, the issue in this case is whether the dismissal of his first complaint for illegal dismissal on the ground of lack of interest on his part to prosecute the same bars the filing of another complaint for illegal dismissal against Zameco based on the same allegations. Ultimately, the question that has to be resolved is this: whether the dismissal of a complaint for illegal dismissal due to the unreasonable failure of the complainant to submit his position paper amounts to a dismissal with prejudice. The Supreme Court held that the 2005 Revised Rules of Procedure of the NLRC, which was the applicable rules then, is silent as to the nature of the dismissal of a complaint on the ground of unreasonable failure to submit a position paper by the complainant. Nevertheless, the 2005 Revised Rules, particularly Section 3, Rule 1 thereof, provides for the suppletory application of the rules of court to arbitration proceedings before the labor arbiters and the NLRC in the absence of any applicable provision therein. Okay, so the unjustified failure of a complainant in arbitration proceedings before the labor arbiter to submit his position paper is akin to the case of a complainant's failure to prosecute his action for an unreasonable length of time in ordinary civil proceedings. In both cases, the complainants are remiss sans reasonable cause to prove the material allegations in their respective complaints. Accordingly, the court sees no reason not to apply the rules relative to unreasonable failure to prosecute an action in ordinary civil proceedings to the unjustified failure of a complainant to submit his position paper in arbitration proceedings before the labor arbiter. So, the Supreme Court cited Section 3, Rule 17 of the Rules of Court on the dismissal due to plaintiff's fault. The dismissal of a case for failure to prosecute has the effect of adjudication on the merits and is necessarily understood to be with prejudice to the filing of another action unless otherwise provided in the order of dismissal. Stated differently, the general rule is that dismissal of a case for failure to prosecute is to be regarded as an adjudication on the merits and with prejudice to the filing of another action, and the only exception is when the order of dismissal expressly contains a qualification that the dismissal is without prejudice. Thus, in arbitration proceedings before the labor arbiter, the dismissal of a complaint on account of the unreasonable failure of the complainant to submit his position paper is likewise regarded as an adjudication on the merits and with prejudice to the filing of another complaint, except when the labor arbiter's order of dismissal expressly states otherwise. So here, I have just discussed an example wherein the rules of court was applied suppletorily by the Supreme Court.